make a contribution, okay? We have perused through your probably summarized version of your statement, but you give us the full picture of what you intended to, information you provide for us today, okay? Yeah. But if you are ready, we are ready to hear you.
Thank you.
Thank you.
Thank you, Chair. If that's what I may call you, Chair, of course, no disrespect meant by not giving you the appellation justice. Chair, I am here on behalf of Freedom Under Law, together with Ms. Tobela Mkhalise, and we are in the fortunate position of having already made submissions to you. What we would hope to do is to lift out some of the more important contextual factors in an effort to assist the panel to understand what happened in the cases that Freedom Under Law had been involved in, and why what happened in those cases remains of significant importance to this panel and its determination of the questions before it. Our interest in the Commission is set out in our submissions. I won't take you to them, but they're set out in some detail at pages 7 to 14 of our submissions. And I would simply stress for what comes later that we say the following at pages 8 and 9, at paragraph 29, the bottom of page 8. We say, full has Freedom Under Law, and I'll keep referring to ourselves as full, just for shortness. Full has specific expertise and experience in relation to rule of law matters concerning the independence and functioning of the law enforcement agencies in South Africa, with particular emphasis on ensuring that the constitutional mandate is upheld in respect of the appointment and removal of high officers of state tasked with critical law enforcement mandates. And then very importantly, the next paragraph, paragraph 30, apart from the cases set forth below concerning Ms. Jiba and Mr. Mrwebi directly, Full's recent rule of law experience includes being the co-applicant in the successful applications to remove Mr. Abrams as the National Director of Public Prosecutions in a Constitutional Court decision of Corruption Watch, which I will come back to. And we were similarly co-applicant in the decision that is referenced next in relation to Mr. Ntlameza as the National Head of the Directorate for Priority Crime Investigation in two judgments which we referenced there, the Ntlameza decision in the Supreme Court of Appeal and the Ntlameza decision in the full court in the Gauteng province, which is referenced next. And in our submissions, we furthermore go on to tabulate and describe the various adverse judicial findings that have been made in respect of the two individuals concerned before this panel, and we do so in chapter 4 of those submissions at page 27 onwards. We would furthermore just very briefly wish to reference the judgment of the full court in the Freedom Under Law decision, and that full court decision, I'm not sure where you have it amongst your papers, but I'm sure you have looked at it repeatedly in this matter. It's the decision that is referenced in the terms of reference at clause 3.1.2. It's the decision of the Freedom Under Law versus the National Director of Public Prosecutions. And it's a decision that was ultimately in Freedom Under Law's favor before the full bench of the Gauteng High Court in a decision by His Lordship Mr. Justice Motley and Her Ladyship Klapi. And we would just reference for you, again to situate what comes next, what was said by the full court at paragraph 94, where the court, referencing the Ntlameza judgments that I've just stressed, said that this court is of the view that the adverse findings and comments made by the courts against Jiba and Mrwebi have a direct effect on and erodes the public confidence in the NPA as a law enforcement agency. And the court, at the end of that paragraph, said, "We accept the view that the SCA, that the continued presence of such high-profile public officers in their positions under the circumstances, even for one day longer, should not be countenanced." So we do that by way of the background to what comes next in our overall scheme of the submissions. And we stress that this inquiry is, and we do so without suggesting any disrespect. The panel has been sitting and listening to the evidence, of course. But we would submit with the greatest of respect to it that this inquiry is much more than about Ms. Jiba and Mr. Mrwebi as individuals. And we are going to want to try and lift out from our submissions 3 central points for the panel this morning. The first point is that the question of whether they are entitled to remain in office is an objective question. It's an objective question about the integrity and the reputation of the NPA. And in that respect, we will demonstrate that the stain upon the NPA has already been confirmed in binding and non-appeal judgments, which will weigh very heavily with the panel, because they confirm that Ms. Jiba and Mr. Mrwebi, in the cases that they were appearing in, misconducted themselves before the courts that they were meant to be respecting. And we will highlight in that respect how the Supreme Court of Appeal in Interim has confirmed that such adverse comments against officials by judicial officers is in and of itself a very strong factor. In fact, the Supreme Court of Appeal says it's dispositive of the question of whether they're fit and proper. The second question we wish to highlight for the panel is that the objective nature of this question entails far more than the NPA Act, far more than the Constitution's injunction as well, that we as South Africans are entitled to an independent, impartial, and fearless NPA. It entails, we say, our international reputation and our international obligations to root out corruption. And we stress in this respect that the adverse comments in the binding judgments are already a malignant taint against the perception of their independence. And in this context, again, objectively speaking, we will draw attention to the decision of the Constitutional Court in the Corruption Watch case dealing with Mr. Nkosana and what has been described as his golden handshake, and the question of whether Mr. Abrams in that same case was entitled to stay on as the National Director of Public Prosecutions. Because we will highlight for you through that case that the Constitutional Court has stressed that where there's been an abuse of power in order to ensure that individuals remain in power, then that taints the perception of those individuals' independence. It's a very important passage in the Constitutional Court's judgment, which we'll come to in a little more detail. And that will be our second feature of what we wish to highlight by way of context for the panel. To stress that it's an objective question around independence and the perception of independence and impartiality. And we say that perception has been irremediably undermined. It's been torpedoed fatally, we say, by the fact of the judgments over many years. And despite those judgments, the fact that President Zuma first and then Mr. Abrams second didn't do anything. Quite the opposite. They protected Ms. Jiba and Mr. Mrwebi. And as I say, on the authority of the Constitutional Court in the Corruption Watch decision, that will weigh very heavily with the panel, we say, with respect. And then third and finally, we wish to lift out for the panel that the complaints that are leveled at Ms. Jiba and Mr. Mrwebi, in other words, that through their conduct they've objectively tarnished the image of the NPA, is not relegated to something of the past. It is conduct that is ongoing. And we say so in the context of complaints highlighted in our submissions around the contemptuous conduct by both individuals in the teeth of the order that the full court granted, where the full court stressed that they were not permitted to return to their offices, even though they were on some form of special leave that Mr. Abrams had granted them. They were not permitted to do so, and they were not permitted to do so pending the finalization of the appeals that have been lodged in various cases by them. And so we will stress that this is not just conduct that one reads about in the law reports, in binding judgments of different divisions, but that the conduct is continuing. And in that respect, we will attempt to highlight that these are not individuals that show contrition and a concern to do right. They are indeed, as His Lordship Mr. Justice Mcquarry said in the GCB case, he said they are remorseless and they display an inability or a wanton refusal to appreciate the damage that they've done and continue to do to the rule of law and their officers. We do all of this, we make these 3 points, mindful of the terms of reference that stipulate that this panel is inquiring into their fitness to hold office as senior prosecutors, with reference to, as the terms of reference say, and at the discretion of the chairpersons of the inquiry, but not limited to matters raised in or arising from the very cases that I've just stressed we will be attempting to highlight for the panel. If it might assist the panel in what's going to come next, I would like to, with the panel's leave, just hand up the extracts from the particular passages from these judgments which we'd like to highlight. I've given a copy to our learned friends. It's not a voluminous bundle, it's very short, but it will assist so that the panel doesn't have to write down as I'm talking.
You may do so, thank you. And while we are doing that, can I just do what I have, or what the panel has done with all the people who have come to address us or to make submissions. We try as much as possible to give the correct pronunciation of people's names. Mrwebi is written Mrwebi, but it is pronounced Mrwebi. So you pronounce that R as a G. Yeah, it shouldn't be too difficult. No? It's a Mrwebi and not a Mrwebi. Because every time you say Mrwebi, I'm trying to think, who is that?
Let me immediately say thank you, Chair, that Mr. Mrwebi is going to be somebody that, his name, I will struggle with, that's just my mistake.
I know.
But I meant no disrespect to him or to the panel.
Yeah. We got it wrong all the time and we had to correct people. Yes, thank you.
Chair, so if I might move then to the first aspect which we wish to touch on, this contextual idea of there being very serious adverse findings in binding judgments which are not appealed. We have watched along with the rest of the country as the panel has engaged the issues around the withdrawal of the charges against Duly, etc. And the panel will of course weigh that evidence. But we would add that additionally there is a further and already existing basis to find that both advocates are not worthy of their positions and must be removed in order to ensure that the NPA is not tainted any longer. And that path is by way of the Supreme Court of Appeal's decision in Interim and its confirmation of the full court's findings before it in the same case. And in considering what the courts held, we will recall what we have cited in our submissions about the duties of a prosecutor at pages 19 to 23 of our submissions. And I shan't ask the panel to read those, but I just wish to highlight very quickly what we wish to emphasize at those pages. At page 19, paragraph 52, we say that the inquiry should keep in mind, Chair, that higher standards of conduct to Ms. Jiba and Mr. Mcquarry than those applied by the GCB and the courts in relation to their potential striking off from the role of advocates are applicable for the panel. And we say that that's because the inquiry's mandate is not to determine whether they are fit and proper persons to practice as advocates, but rather to inquire into the very different question whether they're entitled to hold the high public offices that they have held and continue to hold. In other words, to hold that office, it is necessary for you to be an advocate, but it's not sufficient for the holding of that office. There's something more required of you. And the judgments which we used to reference make that patently clear, particularly in the Supreme Court of Appeal and Tlemeza decision. And we stress at the next page that their respective positions are two of the highest public offices within the administration of justice. And they've been endowed there with substantial legal responsibilities. I wish to just pick out that one of those responsibilities you'll see at paragraph 58.1, page 22, so 2 pages on in those submissions, is that under the NPA's Code of Conduct, which of course they've all had to sign and that they are exemplars of, or should be, that Code of Conduct obliges both of them to cooperate with the police and the courts and the legal profession. And giving further content to that obligation, over the page at page 23, paragraph 62, you'll see that Chapter 2 of the Practical Guide to the Ethical Code of Conduct provides further that a prosecutor is, and this is important, we'd, with respect, ask that you underline it, is personally responsible and accountable for the presentation of his or her case in court, must never mislead the court or suppress evidence, should assist the court in arriving at a just verdict, and then must refrain from any conduct that may violate the decorum of the court. Now, as the panel knows, as I've already highlighted, freedom under law was successful before a full bench of the North Gauteng High Court in the case I've said is referenced in your clause 3.1.2 of your terms of reference. I'm just going to call it the full case from now on because it was freedom under law that brought the case. And it was a judgment by His Lordship Mr. Justice Motley and Her Ladyship Tlapi. And it, in that case, was stressed by freedom under law that there was a challenge directly to President Zuma's failure to appoint a commission of inquiry under the Act, because he had failed to take into account that there were adverse judicial findings. He had not given them sufficient weight. And it was further suggested that Mr. Abrams' decision to withdraw charges against Ms. Jiba was unlawful. Both those decisions were challenged, and successfully so, by freedom under law. So it went to court out of respect for the final and binding judicial decisions that were extant at the time and which remain extant today, and which we submit weigh very heavily in the determination of their office, or of their fitness rather, to remain in office. And we go further to stress that this taints the perception of their independence, their competence, certainly in respect of the courts themselves. And I've just referenced for you their professional duties under the Code of Conduct in that regard. So when freedom under law's application was brought on the 6th of November 2015, final court decisions were and are in place. And they're not just one decision. They are a slew of decisions, as you are well aware. And those decisions, we say, do 3 important things for this panel. First of all, they confirm the objective nature of the inquiry. Secondly, they confirm that judgments are materially relevant considerations for this inquiry. And thirdly, they confirm that public findings impact very seriously on public perception around the independence and the capacity of the officials concerned. And as I will stress, in making all of this, this is going to be linking to our second point, which I'll come to a little down the road, but I'm just flagging it now, which is that despite those judgments, no action was taken against the individuals concerned. So in the context of perception, the perception is that the individuals concerned were protected from any form of inquiry. And that obviously taints the perception of their own independence, and we'll get back to that, as I say. So in the context of this case, and I've given you the extracts from the Helen Suzman Foundation case, it's effectively Helen Suzman Foundation versus Tlemeza, we say that the case is no doubt of pivotal importance to the panel. The court pointed out, And you'll see this on the first page of the extract, that at paragraph, well, it's in fact not on that page, but just so that I can situate it for the panel, it was in fact the paragraph before paragraph 30 that the court stressed that the meaning of fit and proper for the head of DIPSI under section 17 of the SAPS Act is the same as fit and proper under section 9 of the NPA Act. Just so that we understand that we're on all fours when it comes to the question of fit and proper. And we stress here that obviously if someone is not fit and proper to have been appointed in the first place on the basis of damning judicial findings, then it's difficult to see how they could be fit and proper to remain appointed in the face of damning judicial findings. And we, again, as a contextual point, stress that in this case there were judicial findings by a single judge. In the Ntlemeza case, it was one judge who had made findings, but we are, of course, dealing with a situation where things are much worse. There are numbers of judges in different divisions, including our highest courts, who have made the adverse findings that they have. And importantly, in the spy tapes case, as you'll know, the Supreme Court of Appeal said that it was disconcerting to see that it had to criticize Ms. Jiba in this case after it had just previously had to criticize her in a previous case in Duly. So let me then just, if I might, briefly lift out the main points from the judgments, and just to stress that there are 3 points. There are 3 judgments. There's the main judgment by the full bench. Then there was an attempt by Mr. Ntlemeza to try and appeal the judgment, and there was a Section 18.3 application, and there was a separate Section 18.3 judgment. And then thirdly, there was, on that Section 18.3 aspect, a Supreme Court of Appeal judgment. And I've given you the relevant passages, and as I say, I hope that it will assist time-wise. There are, at least in the main judgment, that's the main judgment of the full court, there are 4 central findings which we say are particularly helpful to the panel. The first, which you'll see at paragraph 31 of the judgment, it's on the first page of that note you've received, is that whether someone can ever be said to be fit and proper in the face of judicial criticisms in final binding judgments is an objective question. So it's not whether I subjectively think that they are fit and proper, or whether Mr. Aronsa thinks that they are subjectively fit and proper, or frankly, even whether the panel subjectively thinks that they're fit or proper. The question is whether they are objectively so, as a matter of law. Because, as the court said at paragraph 33, the appointee must be a fit and proper person. The second point is that in considering the objective question of fitness, a vital consideration will be the final and binding judgments of a court. At paragraph 36, the full bench said the following, and it's quoted for you in the middle of that page, that judicial pronouncements are direct evidence that a person lacks the requisite honesty, integrity, and conscientiousness to occupy the position of any office, not to mention an office as important as that of the national head of the DIPSI, where those qualities are paramount ones. And the court went further to say at paragraph 37, since no appeal lies against them, the findings are dispositive of the question whether the person is fit and proper. The third point to lift out is that the judgments are, of course, centrally relevant considerations, so much so that if they are not properly taken into account by a court or with respect to this panel, then that may well be an irrationality in and of itself. Because as the court said at paragraph 37, dealing with the president in that case, the president is not free to brush aside a considered opinion of a superior court which bears upon the very point. And said the court, this arises not from judicial vanity, but from the provisions of the Constitution itself. Because, said the court, the core business of the court is to decide disputes which can be resolved by application of the law. The fourth point to stress from the judgment is that at paragraph 38, said the court, there's no room to dispute Matujane J's findings. said the court, the minister was aware of the remarks made in the judgments, but he nevertheless took the view that they could be ignored in the exercise of his powers. And we say this resonates very heavily for the question of perception. Because here, in our case, President Zuma and Mr. Abrams remained steadfastly unmoved by the judgments. And that heightens the damaging perception problem associated with both advocates, Jiba and Mrwebi. And that, as I say, is a point I will come to again, footnoting for you later, the issue of the Corruption Watch decision. So those are 4 points arising from the main judgment. And then there's the Section 18.3 judgment. I've attempted to give you the relevant passages starting on the second page. You'll see it starts at the bottom of that page, Helen Suzman Foundation, Mabuse J, Colopin J, and Bakwa J concurring, and then the passages are on the next page. First of all, the full court confirmed at paragraph 10 that the remarks by Matajana J were dispositive of his fate. And on that basis, the court felt compelled to keep Mr. Ntlemeza out of his position, even pending appeal. Second, the full court reiterated at paragraph 11 that Mr. Ntlemeza was objectively disabled from continuing to hold office by virtue of those judgments. Said the court, someone whom the superior court has pronounced lacked honor and integrity, and who was at all material times disqualified from being appointed to the highest office, is inconsistent with the provisions of Section 17 of the SAPS Act, or in our case, the NPA Act, Section 9. The third point stressed in the judgment is that the harm to the public is manifest and arises as a matter of objective fact, again, from the judgments themselves. And this is important. We ask that the panel pick up a highlighter or a pen next to paragraph 11, because the court said his continued occupation of that office in the face of the lingering remarks by a superior court will unavoidably cause irreparable harm to the administration of justice, the public, and the public perception. The findings against him have become public knowledge. What impression in the perception of the public would his continued occupation of this office create? And we would just wish to, for a moment, pause to situate the context of our case, which is that long before the GCB had filed its case against the two concerned advocates on the 1st of April 2015, the conduct of both the advocates was a matter of public knowledge and disquiet. There had already been adverse comments in Murphy J's judgment on the 23rd of September 2013, now nearly 6 years ago. And then there was the damaging and disquieting comments made by His Lordship Mr. Justice Gorvin in the Boyson case on the 26th of February 2014. And then the comments by the Supreme Court of Appeal in Duly 2 on the 17th of April 2014. The point simply is there are numbers of judgments going back all the way to 6 years ago where they have become public knowledge, and the impression that they've created in the perception of the public is that the continuation, already way back then, of their offices would be a taint upon that very office. The fourth point arising from the Section 18.3 judgment is a short one, but an obvious one. Said the court, a person so disqualified cannot cling to office for 1 day longer, including pending appeal. Because, said the court at paragraph 26, such a person's lack of integrity permanently disqualified him from being appointed to any public office. Accordingly, this court cannot allow a person it regards as unfit to continue in high public office for 1 day longer than is necessary. And the full court in that main judgment had made clear that in the context of determining that fitness, such findings by the court remain as a lapidary against the candidate until such findings are appealed against successfully, and we know they never were. Third judgment then is the Supreme Court of Appeal's decision in Ntlemeza. It's on the next page of the handout I've just given to you. Lieutenant General Ntlemeza had applied for leave to the SCA, but his leave was denied. He then petitioned the SCA for leave, but that was denied. And then what he attempted to do was to appeal through his automatic right of appeal under Section 18.3, the very order and judgment I've just been referencing to you, where the full court had said he couldn't remain in office for 1 day longer. And so the SCA held as follows. First of all, it confirmed that the Section 18.3 order had been granted correctly. At paragraph 32, it said that the High Court reasonably apprehended on the evidence before it that further appeals were in the offing, and issued an order that sought not just to crystallize the position, but also to anticipate further appeal processes. And in those circumstances, the SCA said that it was appropriate to remove Mr. Ntlemeza from his position, despite the pending appeal to the Supreme Court of Appeal. And it said that it was justified in that order for 3 reasons, which we wish to stress. First of all, said the SCA, it was due to the constitutional importance of the SAPS and the DIPSI in particular, and the public interest in the manner in which it discharged its functions. Secondly, it was the vital position that was occupied by Mr. Ntlemeza at the DIPSI. And lastly, were the adverse judicial pronouncements concerning Mr. Ntlemeza. That was all said at paragraph 45, which I've cited for you on that page. Now, we understand that in this inquiry, and it's been true also in the other cases where we've been against Ms. Jiba and Mr. Mcquarry, is that there's been much effort made on them, on their parts, to suggest that, well, let them first finalize their appeals. All of this is going to be sorted out on appeal, and nothing should happen in the interim. But with respect to that argument, the fact that the GCB decision is on appeal, first of all, it deals with a different statute and a different test in respect of advocates. But in any case, it's clearly of little moment because of what the Supreme Court of Appeal said in Ntlemeza. It confirms that action must be taken to protect the public's interest in vital constitutional organizations, even where an appeal is still anticipated. The fact that they were appealing didn't allow, or he was appealing, didn't allow Mr. Ntlemeza to remain in office at all. And why? Well, said the Supreme Court of Appeal in paragraph 45, and it's quoted for you. It said this: Tuchton J's remarks, His Lordship Mr. Justice Tuchton had been involved in an earlier stage of the case, and the court was commenting on it. The court said, Tuchton J's remarks do not have a neutralizing or any other effect of disturbing the adverse judicial finding against General Ntlemeza. The proper functioning of the foremost corruption-busting and crime-fighting unit in our country dictates that it should be free of taint. It is a matter of great importance. The adverse prior crucial judicial pronouncements and the place that the SAPS maintains in the constitutional scheme, as well as the vital role of the head and the public interest at play, are all factors that weighed with the court in its conclusion that there were exceptional circumstances in this case. So if I might draw all of those cases together very quickly and stress what we say they confirm for the panel. First is that they confirm for the panel, we say that the extant judgments that have criticized Ms. Jiba and Mr. Mrwebi were always enough. That they happened to stay in power for this long and not have an inquiry instituted against them doesn't change the fact that those judgments were always enough. And it's not just one judgment, but an avalanche with respect to judicial criticism. And the fact that they were protected during that period of time by President Zuma and Mr. Abrams, despite those findings, simply highlights the reputational damage that has been done to their offices. The second point we stress from these judgments is that the question of fitness is, as I've said repeatedly, it's an objective one. The judgments themselves confirm unfitness in the way that both advocates conducted themselves in the very courts that they were appearing in, and where, as I stressed for you in reading from the NPA's Code of Conduct, each of them is personally responsible for the decisions that are taken in those courts. Not least of all because of the high office that they occupy, and particularly after they've already been criticized in a previous decision, one would have thought then that they are on their highest warning as to how to act going forward. Public perceptions, we say then, are affected, as these judgments confirm, by their continued incumbency at the NPA. And we, with respect, say that the Supreme Court of Appeal's decision helpfully confirms that this panel should not be waylaid from its duty simply because there is an attempt to appeal the GCB decision or any of the other decisions. And it's now to public perceptions that I want to turn next. That's the second topic of our presentation. We speak here about public perceptions, and we do so in the context of our constitutional and international law obligations. We've made very full submissions, we don't intend to repeat them, on the standards of independence applicable to the very high offices that are held by both Ms. Jiba and Mr. Mrwebi. But we wish perhaps to step higher, as it were, for a moment, by looking at the Constitution and international law together. This panel will well know, and Justice Mokgoro, you were in some respects part of this movement in some of the judgments from the Constitutional Court, that our court now embraces international law. South Africa's progressive approach to international law has moved it from the periphery to the mainstream, and so international law now is not only domestically binding, but indeed we can happily say that the arc of South African law now bends towards international law, and that's most recently made clear by the South African Constitutional Court's decision in the Law Society case around the disbandment of the SADC tribunal. I don't need to give you the reference, I'm just highlighting what I think is obvious to the panel. And for present purposes, again, I don't need to give you these references. They are all already contained in the Glenister judgment of the Constitutional Court, which I think we're all familiar with. But there are particularized obligations on South Africa around fighting corruption through the most independent of institutions that are for South Africa binding at the level of international law. They include the UN Corruption Convention. They include the African Union Convention Against Corruption. And they include, as the Constitutional Court in Glenister stressed, the OECD reports on corruption. And again, I don't have the time and I don't think it's necessary to take you through those, but I wish to simply stress that those conventions and the OECD report make the following patently clear, as a matter not just of our constitutional law, but as a matter of our international law. First of all, that anti-corruption bodies, and the head of these bodies, obviously in the form of directors of public prosecutions, must be shielded from undue political interference. And those conventions and the OECD report stress that it's in systems where the risks of undue interference are substantially higher, I stress, it's in systems where the risks of undue interference are substantially higher that our obligations are accentuated. What does that mean in plain English? It means that if you know in a country that you are facing an onslaught of corrupt behavior, and I think we can accept that that is a difficulty for South Africa, sadly, then the perceptions around the type of independence required in the fight against that corruption is commensurately higher. And in that context, we would merely wish to stress that our international law obligations, together with our constitutional ones, could not then countenance Ms. Jiba or Mr. Mcquarry remaining in office. There are 2 points which we stress here. The first is that respect for the rule of law requires that whatever this inquiry decides, in light of this constitutional and international law obligations I've mentioned, that whatever the inquiry decides, it would require a result that underscores the imperative of non-interference in the independence of the NPA and its national director. Allowing Ms. Jiba and Mr. Mrwebi to remain in office would not secure, we say, the depoliticization of the NPA. and it would not undo the very real perception problem that is associated with them. Given our levels of corruption in this country, it's therefore imperative that there be no taint in respect of the NDPP. The standard is higher as against their officers, precisely because the risks are higher in this country. So their independence, real and perceived, must be beyond taint. And we know this, as I've said, from the Constitutional Court's decision in Glenister. And again, I remind the panel of that which it knows. The Constitutional Court in Glenister, at paragraph 207, said something which is really at the heart of this very inquiry. It said, public confidence that an institution is independent is a component of or constitutive of its independence. So public perception lies at the very heart of the institution's independence. If the public loses confidence in that independence, in that office, then it's no longer independent. Because it's that public confidence that is constitutive of, said the Constitutional Court, independence. That's the first point we stress here from our international and constitutional obligations. The second point is the following. We say that the taint in respect of their officers is compounded by the facts in this case. It's compounded by the numbers of judgments we know that have criticized them and which have never been acted on by the powerful. But we know that Mr. Abrams and President Zuma have been severely criticized by the high courts for protecting Ms. Jiba and Mr. Mcquarry in the face of those binding and damning judicial findings against them, and in highly charged political cases, no less. And here I need to stress what has gone on in the case we were in before the full court in Gauteng in the Freedom Under Law case that I've already mentioned. You'll recall that in that case, the order ultimately granted by the full court was at paragraph 107 of the judgment. And as I said at the outset of my address, there were two decisions that we were challenging. We were challenging, first of all, the decision by Mr. Abrams to withdraw the charges against Ms. Jiba. And secondly, we were challenging the decision by the President not to institute an inquiry despite these adverse judgments. And at paragraph 107 and 108 of the full court judgment, you see the order that is given. And it's important that I take just a bit of time to highlight this for what comes next when I reference the Constitutional Court's decision in Corruption Watch. Because in the judgment and its order, first of all, the court finds that Mr. Abrams and and President Zuma had acted unlawfully in the way in which they had effectively protected Ms. Jiba and Mr. Mrwebi. And in the order, you'll see in paragraph 108.1 of the judgment, the court says, the decision taken by the National Director of Public Prosecution on the recommendation contained in an opinion by the regional head to withdraw charges against the Deputy National Director of Public Prosecutions, Ms. Jiba, is reviewed and set aside. And secondly, the court said the failure by the President to suspend and institute inquiries into the fitness of the two individuals is reviewed and set aside. Now, you can't read that order in isolation. You need to read that order together with what the court said about the efforts by Mr. Abrams and President Zuma to protect the individuals concerned. In relation to Mr. Abrams, the court said the following at paragraphs 55, 57, and 58 of the judgment. And when you listen to what I'm about to say, I want to underline for the panel that all of this amounts to an abuse of power, that phrase, an abuse of power, by both President Zuma and by Mr. Abrams. At paragraph 55, said the court, it's the court's view that the version of Abrams and Mokgoro raises serious questions of credibility. At paragraph 57, said the court, the explanation given by Abrams and supported by Mokgoro to the effect that the decision to withdraw charges purportedly taken by Mokgoro was disguised as a form of recommendation is bizarre in the extreme. And then at paragraph 58, the court said, to opine and make recommendations which later turns out to have been a disguise as a decision is disingenuous and lacks integrity. So that's what was said about Mr. Abrams' decisions. In respect of President Zuma's decision, I would simply ask the panel to reference for itself, it can read it in its own time, paragraphs 91, 92, 93, 94, and 95 of the court's decision. Because there the court says, and it says so in terms, that the decision by the President not to institute the inquiry into the two individuals concerned amounted to a failure of his own duty. And it said, there is no explanation provided in the papers as to why the President failed for a period exceeding 1 year to act, even after having been requested to do so. And says the court at paragraph 94, this court is of the view that the adverse findings and comments made by the courts against Jiba and Mrwebi have a direct effect on and erodes the public confidence in the NPA. And the court says, the President was questioned in Parliament about his views on the adverse comments made by the courts. It's not stated in the President's affidavit as to what prevented him at that time, before the launch of the GCB case, to suspend the two individuals and institute inquiries. And contrary, they say, we are of the view that the President's failure to act under the circumstances constitutes a dereliction of his constitutional and statutory duties. So that's what the court had to say about those decisions. And it had to say that in justifying the orders and setting them aside. Very importantly, that abuse of power is no longer challenged. And we need to stress that. President Zuma originally appealed that decision. But he then, through President Ramaphosa, withdrew. So the President's office withdrew its appeal against that decision. And that's made clear at page 130 of Freedom Under Law's bundle, to the extent that the bundle is paginated in the same way as mine. But at page 130, you will see that the State Attorney writes to the parties in the Freedom Under Law case. And actually starts at page 129, where the State Attorney writes to the parties, and he says at page 130, a single application for leave to appeal was filed on behalf of the NDPP, the regional head, and the President. And then they say, we advise that the President has decided not to proceed at all with his application for leave to appeal. So, what does that mean? It means that the President's decision that I've just described to you, his failure to do his duty, the recalcitrance that this full court criticized, is not appealed at all. It's accepted that there was an abuse of power. The second point to stress is that up until the day before the leave to appeal hearing, on the 4th of October 2018 last year, the National Director of Public Prosecutions, Mr. Abrams at the time, and the NPA and the regional head were still appealing. But the day before, they also gave notice that they were withdrawing their appeal. And to that, would wish to just hand up for you, it's nowhere in the bundles, but the letter and the notice of withdrawal. In fact, it's just enough to give you the notice of withdrawal. Our learned friends, I think, are well aware of this. They were involved in the case. They were there on the same day as I was. But for benefits of the panel, the notice of withdrawal is handed up to the panel. Thank you.
If you have enough copies, can you just extend the courtesy?
I think we've managed to get copies around the tables for everyone.
Thank you.
Chair.
Madam Chair, is this new additional evidence? Is this now a witness, or is he making a submission to assist the panel in shaping what the test should be for fit and proper, and what you should decide, what standards you should apply, like KSAC did yesterday, which I found extremely, and I'm sure the panel did with respect, extremely helpful. Mr. Du Plessis is now engaging in the merits of the case with reference to other court cases, which has not been adduced through the normal channels of a witness, which would have given Ms. Jiba an opportunity to respond to them.
I think we are losing you. Can you just repeat what your question and what you think should be done? Because our impression was that this is an objective submission.
It's clearly not, Madam Chair, with respect.
Is that what you say?
Mr. Du Plessis, on behalf of Full, is clearly more than encouraging you to find, well, we speak for Ms. Jiba that she's not a fit and proper person on the basis of several judgments that he has referred to. He has not referred to the facts that are before you, which would determine whether or not she's fit and proper. We know the judgments that are before you. Mr. Du Plessis makes very, very important and helpful comments about the test and our obligations, the obligations of prosecutors, which we firmly embrace. But we say your job as a panel with respect is to take into account the facts that have been brought out in this Commission of Inquiry. So I had asked whether what Mr. Du Plessis is now ending up, is this now further evidence that he's giving, because he's not a witness. So we object to this continued attack on Ms. Jiba without reference to the facts that's before you.
Yes. He has handed us a notice of withdrawal in order to explain the issue that he is addressing, the objective issue that he is addressing. The fact that if you withdraw your appeal, the assumption, or actually the fact is you accept the findings of the court. And that's the point that he's trying to make. And that is an objective point. Isn't it?
It's with respect not the only point that he's making. He's now saying that because there's also a context, and we haven't had the opportunity of placing that context before you. We are here to present our closing submissions today based on the evidence. Now there's an additional aspect. I'm sure you'll give us time to also address any other issues that he has raised that are of an evidentiary nature. The reason why there was no further appeal against this is quite obvious and quite simple. That is why the panel is here. The President decided, instead of pursuing these matters through the courts, I'm going to appoint an inquiry in terms of 12.6. That is the reason why.
And he's giving us perhaps an additional perspective. That's the way we understand him. But before we go ahead, you want to ask a question?
Mr. Arendse, isn't it that we accepted that the facts that would have been before the other courts, whose judgments are before us, are facts that are accepted by the inquiry?
Yes, Ms. Vilakazi, and these facts speak for themselves. They appear from the judgments.
What's the problem?
It is not for Mr. Du Plessis to come and interpret what those facts mean and what they should mean to you and how the panel should apply these facts. That's not his job.
Would you accept that he's giving us a perspective of the facts?
I've already with respect, Madam Chair and honourable panel members, stated our position that we find many aspects of Full and Mr. Du Plessis' presentation extremely helpful in terms of how the panel should go about in determining what standards to apply, what law to apply, and like KSAC did yesterday. And we embrace it. But Mr. Du Plessis today is going far beyond KSAC did yesterday. They are not here to just help the panel. They are here to implicate Ms. Jiba further with reference to these judgments and by reading from other judgments, Shlemeza and other judgments. These are matters that we will argue, the parties will argue. He is in effect giving evidence.
I'm afraid that's not the way I understand Mr. Du Plessis' submission, but you want us to go and discuss it?
Can I ask something about? And I'm not talking about your objection. I'm just trying to understand. The one thing that you say is that you accept what he says about the law and the interpretation thereof. That you accept. What you don't understand is when he seeks to unpack the evidence and as to find in a particular way. I was just trying to understand that. And then he says he goes beyond KSAC. So which part talks to him going beyond KSAC, and which part do you accept that this is helpful and the latter is not helpful, if you know what I'm trying to understand?
I thank you, Advocate Morocco, because I think by asking that question, it clarifies the position. It is the part where he now purports to apply the facts of those cases that are before you, that have been determined, and that is a matter of argument, when he applies it now to Ms. Jiba. Now we know there are other facts, new facts, that have come out during the course of this inquiry. That was the purpose of this inquiry. Now, he is now urging you to find, on the basis of the law, which we don't have a problem with in his presentation, that we are bound by international law. We know that. We don't need Mr. Du Plessis to come and tell us that. And we know the high standards that we expect of our prosecutors and of the office of the NDPP. We expect nothing more, nothing less than the highest standards of integrity. We know that. But now he applies facts that have been found in these judgments, and he goes beyond KSAC. Mr. Naidu didn't do it yesterday, and he now urges you on the basis of those facts, and then in addition he refers to Shlemeza, Glenister, and those cases, and he urges you to find Ms. Jiba guilty, that she is not a fit and proper person. That is the thrust, and that is the trend of his evidence now. This is not going to, I anticipate some other pieces of paper now to come from Mr. Dupree.
There are no other pieces of paper. Thank you, Chair.
Madam Chair.
Sorry?
Okay, before I do that, you want to say something?
Madam Chair, maybe I should just direct us to the rules. KSAC and Full were admitted as third parties pursuant to a request that they made in December, which we accepted and which foreshadowed this. For me, whilst I don't express an opinion on the stance they take, it is foreshadowed in what they've put before the inquiry, in their request dated 20th December and in the submissions which they gave us in January. There was no objection to the inquiry accepting this, and it was accepted into the Dropbox at that time. I simply want to alert the panel that that was the approach adopted.
Madam Chair, just if I can, on behalf of Advocate Mcquarry,
I always forget you.
Thank you, ma'am. Now I'm here in the corner, ma'am.
Yes.
Madam Chair, I think the point that the Advocate Jiba's team are making, and this has been emphasized now by what's actually been said by the evidence leaders, is they were admitted as parties and therefore they had the right to partake. And the way they elected to partake is to make submissions on the law. And the objection is that if they wish to present evidence, introduce new evidence, new cases, new facts, then they had to do so as all other parties through witnesses, ma'am. And that is what the objection is, that I understand, and that is where the deviation is now coming. They can't be both just a submitter and a party without actually putting the evidence before that we could have had an opportunity to respond to in our evidence, that we would have had opportunity to cross-examine and test and the like. And if I understand correctly, that is where Advocate Ahrens is going, or has been going. So that's our submissions, ma'am.
Yes, thank you, Mr. Rep. But there is no new evidence that is being submitted. This is all evidence which already exists.
May I respond? That's exactly the point. It may not be new evidence. It's evidence that has already been evaluated and that has been decided by courts of law. We've heard additional evidence in this inquiry. What do I do now? Do I say to Mr. Du Plessis now, is your view or Fool's view going to change in the light of this and that evidence that has been adduced in this inquiry? Yes or no? How do I do that? He's not a witness. Their attitude is on the second leg of what we are objecting to, which is their urging that you must now find that Ms. Jiba is not a fit and proper person, is that it's based on judgments which we can read for ourselves. It's based on judgment in relation to which, yes, Ms. Bauer is correct, it's been foreshadowed. We've read their arguments. What Mr. Du Plessis is saying, I've heard before. I was in the full case, I've been in other cases also against him. So today I'm hearing it again. Now he was given an opportunity to make his submissions to the panel in relation to, and they professed to assist the panel. They're now going beyond that. They're not assisting the panel, they are now urging the panel to find Ms. Jiba guilty on the basis of a string of judgments that have been handed down by our courts. Of course, we know. Now do we say to Mr. Du Plessis now, is your and Fool's attitude going to be different now that the SCA has found that has effectively cleared Ms. Jiba? What is he going to say? No, you must still look at these judgments. Govan, Lachodi, Hughes, and Murphy and Brandt J.A. must be, are those judgments still reference points? Because that is the bedrock of his submission.
I'm just afraid you've really lost us, because we see it differently. We see this submission as articulating the standards, for example, that are applied when we consider our mandate, when we consider our terms of reference. And examples of existing case law and findings of existing case law are being made. In other words, we are getting a perspective of how these objective standards are applied based on existing findings made by courts in existing case law. And if that is not going to be helpful to the independent decision and recommendations that the panel is going to make, then I don't understand what the objection is all about. We see it differently. Yeah.
Can I find out? we have just been handed documents that you only saw this morning. If these are withdrawn and he is confined to expanding on the submissions that they had made before, would you have an issue with that? If we say, you are probably right, you probably didn't anticipate these references, would you be willing to then withdraw the objection on the basis that they have withdrawn the submissions specifically with reference to the documents that they submitted to us today? I'm just trying to understand what it is that you're objecting to.
With respect, we have to differ, Madam Chair, because I think we are very clear the basis on which we are objecting. The basis on which we are objecting is because full on entering into the merits of this.
Just to help me understand, you're not
Yes.
answering my question.
No.
Full made a submission, and the submission by Ms. Bauer is that you did not object to this submission being made. You are now saying we did not object to this submission at the time that it was made, to say they are adopting a partisan position. You're saying today, not only are we objecting, and I'm trying to understand, when you say you beg to differ, I don't know what you're differing from, I'm trying to understand. I'm saying to you, they then make a submission, you don't respond or object to the submission. Today, they say, we're going to highlight some of the points we made in the submission. What I'm trying to understand is two things. Are you objecting to that they were trying to do at the beginning, as to say, we're going to highlight some of the issues that we've made in the submission? That's the first objection. The second objection is we're going to object to the documents that they have submitted today upon which they wish to address us and upon which they're urging us to have a particular perspective. So it's two legs to this thing. What I'm trying to understand from you is the first leg that says there's a submission and they want to highlight the parts of the submissions that they have made to expand on those submissions, or are you saying you're objecting to both? That's what I'm trying to understand. And not differing with you, I'm just trying to understand.
I'm also not trying to avoid answering your question, Advocate Moroka. You'll be pleased to know. I was trying to do it in the order in which, because Madam Chair had also made some and I was first trying to deal with that. We can't have a problem with full, or like in the case of KSAC, they had made written submissions, we have read them, we understand them, and if the purpose was, like with Mr. Lawson yesterday, to come and to highlight those submissions again and to re-articulate them orally, we have no problem with that. As far as their submissions, especially in the case of full, do however touch on the merits, not just telling us which standards to apply and that we need to apply international law and so on. We don't have any objection to that. We can't. We know our Constitution requires us to apply and to respect international law. So we don't have a problem with that. It's when it comes to Mr. du Plessis effectively taking from these judgments, now applying these standards to Ms. Jiba in this inquiry, in circumstances where there are plenty of other facts that have emerged during the course of this inquiry. Full had every right, they had every opportunity, having been admitted as an interested party. We have no objection that they're an interested party. They play an important role in our civil society, like KSAC does. They're important watchdogs. There was no reason why they could not come and give evidence here and make the points that Mr. Du Plessis has now made up until now, and subject themselves obviously to questions, cross-examination. They may or may not have been cross-examined, I will never know. But Mr. Du Plessis, in our view, has overstepped the mark. He's made his points on the standards and the tests that need to be applied. Now he's seeking to advance argument which affects the merits of the case before you.
So you have an objection in Mr. Du Plessis highlighting aspects of the judgments in order to articulate the standards that he wants us to understand need to be applied when we consider this matter. So your objection is just the highlighting, articulating the importance of, or the relevance and importance of aspects of judgments in order to demonstrate the standards.
No, we don't have a problem with Mr. Du Plessis because he's quite capable of doing that, of highlighting these judgments to underscore and to highlight what standards have been applied in certain court decisions. We don't have a problem with that. But for example, he goes to the full judgment and Ms. Jiba is now accused of being protected by Mr. Abrams and the former president. Now, what is that designed to do? That is designed to influence your thinking, not on the standards, but on the evidence that somehow Ms. Jiba is part of this narrative that goes around Abrams, that goes around the former president, and which we have addressed in evidence before you, and which we are going to address as soon as he's finished in our closing argument. But we're going to address it by reference or with reference to the facts in the case here. Do I not challenge Mr. Du Plessis and say, well, Mr. Abrams' decision to withdraw charges against Ms. Jiba on the what is the fraud? The fraud and perjury. What is the evidence before you, Madam Chair? The evidence before you is that those charges, they were sent back by Mr. Abrams following the court judgment, and they have now officially been withdrawn. So, again, you ask him a question, so what is your stance now? That has got nothing to do with the standards. It's got to do with the merits of this case. And that is the terrain that Mr. Du Plessis is now traversing. And he's pushing the boundaries all the time. And that is the objection.
Does that answer include my question? Because I think that answer speaks to the chair's question.
Okay. The answer to the question is that they must be confined to the submission that was placed before this inquiry.
I get it.
And nothing additional to that. I think one must obviously also be reasonable. Clearly, one can't have an objection to, for example, on a matter of law, if there's been further or additional cases that hasn't been referred to in the submission. Clearly, it must be permitted because those law reports are available to all of us.
So he must refrain from emphasizing any aspects of the cases, the judgments that are already before us. You don't preclude him from doing that.
We say that he should be confined to, when he refers to those cases, that it should be with a view to assisting you in formulating the test that you should be applying, whether or not Ms. Jiba is a fit and proper person. The legal test, which with respect he has already done more than capably.
Du Plessis, you may proceed.
Thank you, Chair. Chair, so in the context of that particular order and the document that I referenced for you, which frankly, of course, is an objective document, it's a notice of withdrawal, and it falls very much within your terms of reference, which specifically say at paragraph 3.1 that you're entitled to have with reference to and at your discretion, but not limited to, numbers of matters raised in or arising from the following cases. Arising from the following cases. One of the matters arising from the freedom under law case is the fact that the orders granted in that case have not been appealed. And the unlawfulness around the failure by the President to institute an inquiry and the unlawfulness around Mr. Abrams' decision to withdraw the charges against Ms. Jiba, those decisions have been successfully challenged, and the President has chosen not to appeal against his decision, having been said to be unlawful, and on account of this document, which frankly I would have been happy to be cross-examined on, because I would have simply said that Mr. Aronson and I were in the same court on the same day when precisely this document was given to us by Mr. Epstein, who was acting on behalf of the President. And in the circumstances, it confirms too that the NPA and Mr. Abrams are no longer challenging the finding that says that he acted in a manner which ultimately was unlawful, bizarre, and in the circumstances, his decision to withdraw the charges against her were irrational and unlawful. So, in that context, we stress the following. We say that the Constitutional Court's decision, and again, I'm very sure I'm not saying anything beyond a question of law, and I'm trying to apply what is a question of law and a finding of our highest court to assist the panel. But we say that the Constitutional Court's decision in Nkosana, I hope I pronounced that correctly, Chair, Asana, that is of relevance to this panel. And the particular quotation is in the document that I handed to you this morning. That's at paragraph 88 of the Constitutional Court's decision. And I need to read it for the panel. As the panel knows, the Constitutional Court was dealing with, we say, a very helpful analogous situation. Because there, the debate was, well, Mr. Nkosana was unlawfully removed from office, and Mr. Abrams was kept in office. And the question for the Constitutional Court is, if Mr. Nkosana was removed unlawfully from office, could Mr. Abrams continue to benefit from the fact that he had been appointed in the place of Mr. Nkosana?
Why would that be relevant to our inquiry?
Let me help you by referencing the paragraph. Chair, says the Constitutional Court at paragraph 88, I next deal with Advocate Abrams. As a point of departure, I must state that not a single party has suggested that he is not a fit and proper person to hold office. As was to be expected, Advocate Abrams seeks to get a lot of mileage out of this. Must he succeed? I think not, says the Constitutional Court. Why? Because former President Zuma appointed Advocate Abrams following his unlawful removal of Mr. Nkosana. That removal was an abuse of power. Advocate Abrams benefited from this abuse of power. It matters not that he may have been unaware of the abuse of power. The rule of law dictates that the office of NDPP must be cleansed of all the ills that have plagued it for the past few years, and it therefore would not be just and equitable to retain him, as this would not vindicate the rule of law. And so we say that it is an analogously helpful passage because it highlights that there is an important perception issue at the end of the day, which is at the heart of that passage. And the perception issue arises from not only the conduct of the official concerned, which of course this panel has been listening to loads of evidence around, but it also relates to the objective question of whether that person benefited, whether the position they occupy in the centrally important place within the state structures, whether that position they occupied is a position they occupied and which they benefited from, arising from an abuse of power.
I don't get that. And I suppose that's what Mr. Aronson's complaint is about. we haven't had any evidence about that. And therefore, for you to ask us to draw inferences from that statement that we make, makes us have to open that debate that we haven't had, or open the parties to ask you about that. And I'm not sure we want to traverse that because it would not be helpful. We're really right at the end of our sell-by date. So that statement doesn't really help us because I'm not sure I see the relevance in the context of what we've been doing.
Chair, let
Do
me...
you understand what I'm saying?
No, I understand, Chair. Let me attempt to assist. So it's relevant in this way. As I said, the very first passage that the court stresses there is that so in other words, as a question of law, even assuming that not a single party has suggested that Mr. Abrams was not a fit and proper person. So in other words, separately, as a question of law, separately from the debates, as you say, Chair, that you're going to have to be having behind the scenes with yourselves about the evidence as to whether there is a fit and proper person in the office.
Evidence that's open here.
Yes, the evidence
Not
that's
behind
here.
the scenes.
Well, the evidence, when you go back and you think about this behind the scenes, I mean in the sense of in your offices quietly thinking about the evidence and trying to go through everything that's happened, then you will have to have in your minds the question of whether, on the evidence that you've got, the persons concerned are fit and proper. That's one part of the inquiry that you are engaged upon. But there's a separate aspect, and it arises from what we say are objective facts, quite separate from the evidence. And the objective facts arising from the case law that I've just highlighted for you in the freedom under law matter, the objective facts show that we now have a decision of the full court which stresses that Mr. Abrams unlawfully withdrew charges against Ms. Jiba, and it's not appealed against. In other words, he abused his power. There can be no debate about it. It's not evidence that one needs to give about this. It is as clear as the court saying that in those circumstances, he didn't act lawfully in the manner in which that particular office was kept in place, and that the president separately did the same thing because despite adverse judgments over many years, he had failed to do anything in that context. So there can be objectively a determination. And as I stressed, because there's no appeal against the particular findings.
I think you are beginning now to tread into a dangerous territory. The point that you're trying to make is that we have to take into account whether an official benefited from the abuse of power. And it is an aspect of the objective standards that you're trying to explain.
Yes, that's all.
You see, if you now go into how to apply that objective standards to the facts of this case, and you go into detail about what the officials did, and therefore this is how you apply that principle, that standard, to the facts of this case, and this is a conclusion that you would arrive at, then Mr. Arendse would have a point. If you stick to explaining the objective standards without applying the standard, we can do that. That is our job. We listen to you, you enlighten us about the standards and how to interpret the standards, but outside of the facts of this case. We are going to apply those standards to the facts of the case. Okay. And maybe, as Advocate Moroka said, if you confine yourself to your submissions, you can articulate the submissions by explaining further, using perhaps what was said in the cases, but leave the application of those standards to the facts of this case to the panel. Okay.
Can I find out so that I'm not unduly or unfairly restrictive? You speak to these issues in your submissions and let me just understand. You have at paragraph 34.
sorry, Chair, I'm in the wrong file.
It's
Yes,
the-
paragraph
yeah,
34.
34.
Yes.
Para 95, the heading there, the charges against Jiba and the decisions by the erstwhile president not to suspend.
Yes.
Are we there?
Yes.
And the submissions there go to that failure.
Yes.
And I'm just wondering, why is it that you don't stick to the submissions that you made in relation thereto, instead of taking the step further, which step was never foreshadowed in these pages, where therein lies the objection about leading further evidence? If you get what I'm saying,
No.
sometimes I don't hear what I'm saying myself, so
No,
if you get it, let's go in.
I've heard you, Advocate Moroka, and I see the concern that has been raised. We say two things. The first is that we're not attempting to do anything but apply the objective findings of the Constitutional Court to this matter. And the important point we stress is that, as the Constitutional Court in its paragraph says, not a single party in that case had suggested that he was not fit and proper, but it didn't matter because there was a separate objective question, whether by virtue of a benefit there was a retention of office which tainted perception-wise the continuation of Mr. Abrams in office. And it goes back to everything we've been saying, frankly, throughout our submissions about perception being absolutely imperative here. And we say that perception is an objective question, and so one of the debates that this panel will have with itself and with the members is there a perception problem arising from the fact that the full court has said that President Zuma over many years, and this I'm not giving evidence, this is what the court found, this is an objective fact and it's not being appealed, so it is as objective as it could ever be, that the court found that over many years there were numbers of entreaties, requests, in light of the adverse judicial decisions, made to President Zuma to appoint a commission of inquiry. And he didn't do so. And the judgment is critical of that fact. And it says that he was, as I read to you, he was recalcitrant in his duty. He didn't do his duty. And so, and it's not evidence, it's an objective reality, is that over that period of time, the individuals concerned didn't have an inquiry and they managed to retain their office. So that's an objective fact, it's not evidence that we're giving. In respect of
Why don't we live with that? Why do we have to go beyond that and talk about perception? Because perception is a dangerous thing to go into. It's not objective at all.
Well, Advocate.
And whose perception are we talking about?
Yes. Well, Advocate Moroka, I think in the Constitutional Court's passage that we've cited, the Constitutional Court specifically said that there was nobody that suggested that he wasn't fit and proper, but the court had to do the objective inquiry. It had to ask itself that very question, and it said that Advocate Abrams, purely by virtue of the fact that he'd benefited from what were unlawful decisions.
Get that. It's because you then couple that with perception. And I'm
Yes.
saying, why don't you limit yourself to the objective facts? You can't say, I will address myself to the objective facts, and these are the objective facts, and then travel beyond that. I must tell you, yesterday we had an engagement about perception and trust. Because those are, you don't ever want to travel into those things. Perceptions in South Africa are underpinned by whole different context. And it would be much easier to go into what are the objective facts without delving into perceptions, because culturally perceptions are different, racially perceptions are different, societally perceptions are different. And all I was engaging you with is, why don't we stick to the objective facts that you have articulated in these submissions of yours, and then go and deal with perceptions? Even though perceptions are important,
Yes.
it's just that you don't want to traverse there, because whose perceptions are we supposed to accept?
You're going to do your job, no doubt, and I say that with respect. You're going to do your job by trying to understand how perception works. And perception works at least at these two levels without you doing anything beyond referencing the Constitutional Court's decisions. The first is that perception is, as the Glenister Court said, and I read to you earlier, it is constitutive of independence. It is a central feature of it, so one unfortunately cannot shy away from it. And secondly, one is going to ask the objective question, as the passage that I've just read from you, for you from paragraph 88 says, that you look to the issue of whether the person concerned happened to be the beneficiary of, in this case, an abuse of state power. When I say abuse of state power, one doesn't need to think about that in any sinister way. It is enough to say that that abuse arises from a decision by the president over many years, despite repeated calls to have an inquiry and not to do so. That is a perception which can objectively be said to be something which is in the face of judgments by various courts, one which gives rise to the suggestion that the individuals concerned have benefited from that. That's an objective point. So I don't take it further than that, Advocate Moroka and Chair. I am making the argument squarely through the lens of that particular passage, and I'm not suggesting anything beyond what one reads there. And of course, I also accept that Mr. Arendse is happy for us to be helpful, as he says, just so long as we don't suggest that Ms. Jiba and Mr. Mrwebi should be found to be unfit. but that's... but that...
Don't try to do what we are going to have to consider. Okay. Yesterday we did discuss perceptions, we discussed pressure, we even went into political pressure. But we did that in particular to unpack the role of public perception and political pressure as it affects prosecutorial independence and the independent discretion, and that is acceptable.
Yes.
Those were the issues and the approaches
Yes.
that we adopted. And it is expected that you don't go beyond just enlightening how to understand the principles. Okay. It is when you try to interpret the principles by applying them to the case or the facts at hand.
Thank you,
I
Chair.
think that is what the objection is. But you are free to even go into perception if you tell us about the role of public perception,
Yes.
the role of political pressure in the exercise of prosecutorial discretion, because that is information that we would like to know.
Yes. And
to
Chair, that...
have.
Sorry,
But
Chair.
how to apply that principled understanding, objective standing to the facts of the case is a matter that will face us,
Yes.
and we will unravel and apply. Okay.
I
Yes.
understand,
You
Chair,
understand.
and we leave it with you at the level that I have. We are not attempting to do more than give you the
Absolutely.
objective, helpful parameters, and
Yes.
we submit with respect that one of those helpful parameters is the Constitutional Court's passage. The point is, in a nutshell, Chair, that even if you were found, or you were to find them fit and proper, there are very significant perception issues, and that the Constitutional Court says as much. It says it doesn't matter that nobody called for him to be removed because he's not fit and proper. That's the point. So, Chair, if I might then move very quickly and finally to ongoing conduct. It's the last chapter, and I'll literally be a couple of minutes in order to finish off.
Going to be, because we have to time and again take breaks.
Yes. Chair,
We have our technicians there who always indicate to us that they need a break for recording purposes, and they have given an indication now. Can you continue when we come back? A break for 10 minutes?
Chair, I'm in your hands. I was going to be 5 minutes longer,
Oh.
but
No. If you can, can we allow 5 minutes longer? Yeah. They say it's okay. 5 minutes longer? About 5 minutes longer.
everybody can hang on for
Yes.
5 minutes. Thank you, Chair.
Sure.
Chair, let me then finish with the last chapter. As I've said, this inquiry has been much focused on the past conduct of the two advocates concerned. But the misconduct, we say, continues. And it continues in the face of the full court's order that had been granted in the case that I've just mentioned. And in that particular case, the full court made it very clear in its order that there was a prohibition, and it was clearly an interim prohibition. It was an interim order and it was at paragraph 4 of the order, at paragraph 108 of the decision, that pending the prosecution to finality of the appeals lodged by Jiba and Mrwebi against the GCP judgment and order, Ms. Jiba and Mr. Mrwebi are prohibited from performing any functions related to their offices in the NPA, and further prohibited to present themselves to the NPA officers and or engage in any discussion concerning any pending cases under consideration by the NPA. And in our submissions, and this is why, Chair, I don't need to be long on this, we've set it out in great detail. First of all, what it was that the full court was attempting to achieve by that order. It was clear that it was attempting to achieve a holding position on an interim basis pending any appeals that might take place. And it was doing so because there was no clarity about how the particular leave that had been granted had been lawfully granted by Mr. Abrams. And so the court said it wanted to protect a situation where the individuals concerned were going back to their offices, particularly at a time when there was such a heightened sensitivity around the case. And we have set this out in great detail in the submissions. I would simply leave again as contextual factors for the panel the following points. And really they're 4 short points, and I hope that they won't take longer than the minutes that I had promised. The first is the terms of reference of this panel. At 3.2.3 of the terms of reference and 3.2.7, the panel knows that one of the inquiries that will be engaged upon is whether the advocates concerned duly respected court processes and proceedings before the courts as required by applicable prescripts and as a senior member of the NPA. That's the first that you will be considering in the understanding of whether there has been contemptuous conduct. The second is that, as I think the panel knows well, Section 165 of the Constitution provides that courts, of course, are vested with judicial authority, and that no person or organ of state, and here we're speaking clearly about organs of state in the form of the 2 advocates. In that context, His Lordship Mr. Justice Murphy in the Duly case made it patently clear that they were organs of state. But Section 165(1) of the Constitution says that no person or organ of state may interfere with the functioning of the courts. And in order to ensure that the court's authority is effective, Section 165(5) of the Constitution, as the panel will know, is obviously making court orders binding on all persons. And it's essentially a rule of law point. The second point is that notwithstanding that clear constitutional imperative, that the authority of our courts is still to be respected and upheld, both Ms. Jiba and Mr. Mrwebi displayed a disregard for the 21 December order, which we've set out in great detail.
There you go again.
Chair,
No,
I think we
I don't want you to interpret those Section 165 with regard to the conduct of the 2 officials.
Chair, we've made those submissions in detail in our written submissions, and we've said that on the basis of, again, objective facts, there is no debate for purposes of both the law on contempt and the objective inquiry around when contempt is shown, that they did return to their offices, and they did so despite the 21 December order. And the debate that is an objective one is, as I say, set out in great detail in the submissions by Freedom Under Law. And there has been no objection to it, Chair.
Okay. You set it out at paragraph 128?
Chair, it's an entire chapter. You are correct when you say that. It's chapter 6 of our submissions, and it's Ms. Jiba and Mr. Mcquarry's further contempt of a court order in the matter full versus NDBP and a resort to a form of self-help. And it's set out at pages 49 through to 74, so it is traversed in somewhat great detail.
Proceed.
Thank you, Chair. And then it is, as an objective fact, again, at page 136, as my junior helpfully points out, there's no debate at page 136 of the papers that the State Attorney confirms that both Ms. Jiba and Mr. Mrwebi had indeed attended the NPA offices over this period of time. The third point, Chair, is again another objective one, and it's to make the obvious point that both Ms. Jiba and Mr. Mcquarry are no ordinary litigants. They are held obviously to a higher duty, and they have to lead by example. They have to lead by example not only because of those professional duties which we highlighted earlier in our submissions, but they have an example that they need to show when it comes to court orders in cases in which they are implicated. So it's one thing to obey a court order in some case in which you're not related, but in a case where you are directly implicated, then, and the order tells you you may not go back to your offices, then there is a heightened duty on you to be an exemplar of obedience to courts. And that allows me to finish, Chair, with a fourth objective point. We will, Mr. Arends is suggesting that he thought I was going to finish with a flourish. Well, he hasn't heard me finish yet. I may as well still finish with a flourish.
Mr. Arends, wait for your turn.
Chair, we've litigated against each other in many courts. He's both my friend and my learned friend. And I don't take any offense. Chair, if I may...
If the courts there allowed it, we don't have time for it. Mr. Arends, can you wait for your turn?
And Chair, so if I might finish off with a fourth and objective point. There's no response at all. We've heard no response from Ms. Jiba and Mr. Mrwebi in relation to this, and they may well have something to say about it, other than through the letters that you see attached to our submissions from the State Attorney. And the letters from the State Attorney on their behalf, and again, I don't take you through it, they're there, really raise two arguments. They raise an argument, no, this point around the paragraph 4 order, it's an interim order, and we've appealed the decision. Well, we've made our submissions objectively. That's just plain wrong on the law. It's clearly not an interim. It's clearly not appealable because of Section 18.3 of the Superior Courts Act. And so in the circumstances, there is an objective reason to doubt what they've said. Their second argument is to say, well, in any case, we're allowed to return to our offices because we've been vindicated by the GCB decision. Now, Chair, let me just pull this together to say, for the best for them, in other words, is that for Advocate Jiba and Advocate Mrwebi, they were suggesting that they were slightly confused around this order, that it might have been a final order which therefore had been suspended by their appeal. They might go further to say, well, there was something about the fact that they'd appealed and the GCB decision had gone their way in the Supreme Court of Appeal, that they were now allowed to return to their offices. At best for them. But Chair, we say, first of all, those arguments are just not availing for all the reasons that have been set out as a question of objective law. But even assuming for a second that they were correct, Chair, what was their duty? And I say this not as any form of inferential reasoning. I don't suggest it as a matter of trying to go beyond my remit. I say it to you as a question of law from the Supreme Court of Appeals decision in Meadow Glen. Now, Chair, in our submissions, just before Mr. Arends complains that he's never heard of Meadow Glen, in our submissions, we cited the case of Merifong, the Constitutional Court's decision, at paragraph 197, page 72 of our submissions. And just so that you know what we said there, referencing Merifong, we said that I'm advised that the Constitutional Court in Merifong held that an organ of state that is uncertain about the legal effect of a ruling is under a legal duty to seek clarification from the courts. And the state should be exemplary in its compliance with such a fundamental constitutional prescript. Chair, I want to just drive that point home with a flourish by reading for you from Meadow Glen. It's a decision of the Supreme Court of Appeal. It says the same thing, but it is very helpfully on point here. As I say, at best, even assuming for a moment that there was any merit to the suggestions that are made by the State Attorney and the attorneys on behalf of Advocates Jiba and Mrwebi, that somehow they could ignore this order. The Supreme Court of Appeal, through His Lordship Mr. Justice Wallace, said the following in Meadow Glen at paragraph 8. He said, having said that, the municipality consented to the court making an order in those general terms. that obliged it to make serious good faith endeavors to comply with it. That is what we're entitled to expect from our public bodies. If they experienced difficulty in doing so, then they should have returned to court seeking a relaxation of its terms. And if there was a dispute between them and the appellants regarding the scope of the order and what needed to be done to comply with it, it was not appropriate for the municipality to wait until the appellants came to court complaining of non-compliance and contempt proceedings. It should have taken the initiative and sought clarification from the court. Its failure over a protracted period to take those steps is to be deprecated. And yes, we do suggest that that is helpful as an objective account of what an organ of state in this context should do. Here it's exacerbated because we know that the individuals concerned have already been criticized by various courts. Those judgments are, of course, what we've been making submissions about. And those judgments have been critical of the individuals concerned for not showing sufficient respect to the courts. Here it's made worse because the individuals concerned under the code of conduct I read to you have a duty to assist the courts and have a duty to comply with all court prescripts. And it's made worse with respect in this case because the order is personal to them. Paragraph 4 is about them. If there was any doubt about what their position was objectively, they should have returned to court to seek clarity rather than choose to ignore the very order which we say was clear in its terms. Those are our submissions, Chair, and we, in the circumstances, don't ask for anything other than that. You consider, as you no doubt will, the various parameters of what independence entails, including perception, and that you do so contextually in this matter, understanding how the various cases which have been referenced by Freedom Under Law came to be and their continuing importance for the purposes of this inquiry. And their continuing importance in confirming that despite all the extra evidence you may have heard, there is one thing that can never be forgotten, and that is that already from 2013 onwards, there have been a slew of judicial findings, adverse, and which, as the High Courts put it in the Ntlemeza case, stand as a lapidary against the individuals concerned. And in those circumstances, Chair, we thank you for the time, we thank you for the engagement.
Before we give counsel an opportunity, or before the panel engages with you, can we just take a 10-minute break? Yes, thank you. Coming back within 10 minutes. Okay. Who starts? Mr. Arendse?
No, we rather than ask them question, we'll deal with that, with their submissions in our own submissions. We fundamentally differ with them, and we accept nothing they've said other than the legal principles. But on the law, sorry, on the facts, they were certainly not here to hear the evidence. So they are of no use as far as the facts are concerned. And of course, if they wanted this panel to deal with the issue of contempt of court, they should have presented that as evidence so that our client is able to answer that. They didn't. And they make the submission as if it's given that there was contempt. So they are quite wrong on the facts. So we'll deal with that, or my leader will deal with that as a response to their submissions.
So you don't have any questions now?
No, we have no questions for them.
Thank you. Mr. Rip?
Thank you, ma'am. We find ourselves in a very similar position to Advocate Jiba's legal team. We will rather debate the wrongness of their submissions with the panel than with the representatives. Thank you, ma'am.
Thank you very much. Mr. Du Plessis? No, Nasrin said there are no questions from you either.
No,
Yeah.
Madam Chair.
Thank you. In the absence of any questions from any of the role players, we'd like to thank you very much for coming forward and providing us with those views, with the idea of assisting the panel, okay? But thank you for your willingness to do that. You may stand down. Are you traveling?
To a consultation in Johannesburg.
Oh, okay. You're not going out of town. Okay, but drive safely anyway. Yeah. Thank you, ma'am. Yeah. Ms. Bauer?
Madam Chair, I understand that Advocate Arendse is going to start and Advocate Rip's going to follow on the legal submissions.
Yes,
They
thank you.
have prepared written argument
Yes.
and we have those on behalf of Advocate Mcquarry to hand up to do that.
Thank you. Mr. Arendse, we are in your hands.
Thank you very much, Madam Chair, honorable members of the panel. These are our closing submissions. I don't intend to read through the heads of argument which you have before you. I will.
We have Mrwebi's. Ms. Bauer?
Been given Advocate Mrwebi's, I haven't been given
Yeah.
Advocate.
We have advocate.
Haven't
We have the Mrwebi submissions before us.
Here we go.
Now we have
Thank you,
written
Madam Chair.
submissions on behalf of Advocate Jiba.
I'm not going
You may
to
proceed.
strictly follow those written
Yeah.
written submissions. I'm going to deal with it in a different way, and hopefully speed up the submission instead of reading out some, well, how many pages are there? Some 60 odd? Some
It's
60
all
odd
right.
pages.
I think you may
Yeah.
proceed.
Madam Chair and honorable members, this is an unprecedented matter, not because this is the first Section 12(6) inquiry of its kind. There has been such an inquiry. We know about the Jinwala inquiry into the fitness of Mr. Pakoli, or Advocate Pakoli, to hold office. We would submit along the lines that Mr. Naidu submitted yesterday for KSAC, that there are some very, very helpful parts of the recommendations made, particularly on this panel's approach to the issues at stake, that this panel, we would urge the panel to adopt them. Now, arising from the Jinwala inquiry, Mr. Simelane, a previous NDPP, was found to have been unlawfully appointed, and he was subsequently, arising from the Jinwala, Mr. Simelane was found to have lied to the inquiry, and this subsequently formed the basis of his removal in a review application brought by the DA in the Constitutional Court eventually. This matter is unprecedented because, first, she is the first woman, female, and black African female to have been appointed to this position, albeit in an acting position. She is the first person, male or female, to have been appointed at the time that she had extensive prosecutorial experience prior to her appointment. And if one compares her prior experience with that of Bulelani Nuka, Vusi Pakoli, Menzi Simelane, and Mr. Kasana, then they had nothing like the kind of experience she had as a prosecutor. Secondly, or thirdly, she is, in the cases that concerns the panel and its terms of reference, she is, or she has been found in some of these cases to have, if we put it more neutrally, erred, not as a prosecutor and not as an advocate representing a client, but as a client, in a capacity as a client. And it is common cause in all of these cases. She was represented by outside senior counsel, and she would have been advised by the internal division called the Legal Affairs Division, LAD. Notwithstanding this, or it's in this capacity rather, that she was the subject of a striking off application by the GCB on the basis that she was not a fit and proper person to be enrolled as an advocate. Now, this related to 4 judgments. The first judgment was that by Murphy J. On the 23rd of September 2013, the Duly judgment. That judgment went on appeal, and the judgment of the SCA was written by Brunt J.A., and that judgment was delivered on the 14th of April 2014. Of 18, thank you, of the judge, 18, 1-8. Mr. Max du Plessis mentioned to you was that as far back as the 1st of December 2015, in the matter of the DA versus the President then and Ms. Jiba and others in the Western Cape High Court, which was a matter that came before Delamo J. Ms. Jiba had indicated in her affidavit in that case that she was willing to abide any decision by the President to institute a Section 12(6) into her fitness to hold office. At no stage did she object to such an inquiry being instituted. The basis of the objection in the full matter was, as Justice Mokgoro and honourable members, you would not be surprised to know, was that we argued amongst other things, but the matter had already been determined by Delamo J in another court, where Delamo J found that the former president had acted rationally when he said, I'm not going to order the 12(6) inquiry because the GCB has already taken this matter to court, so I'm going to await the outcome. Motley and Tsiki, the two justices, was it also right? Sorry.
Tlhapi.
Slape.
Tlhapi.
Slape and Motley. They said no. There's enough before us to indicate a failure to act as required by the Constitution and the law, and the President should have ordered a 12(6) inquiry. So that never concerned Ms. Jiba, because it's always what she wanted. And in fact, one of the issues that we raise very tangentially is, you know, this is almost a case of double jeopardy. She was tried in the courts and now she's being tried here, but we don't take that any further. Now subsequently, of course, as articulated by Mr. du Plessis in the full matter, that is, I think it's in their submissions, 2018-1 SACR 436, North Gauteng. The court said that a 12(6) inquiry must be instituted, and of course that has now happened. Now, apart from the SCA having recently found that in relation to Boyson, Duly and spy tapes, that none of the conduct complained of in that case is warranted a striking off, we also submit that ex facie these judgments and what the judges in those cases had said, nowhere do they say that Ms. Jiba is or was dishonest or that she lied. I think the closest that came was of course Govan J with his mendacious not argument but observation in his judgment, and we submit that was clarified, or that is clarified here in these proceedings by the memorandum from Audes SC who acted in that matter. The panel might recall that my learned friend Katz SC, he likes to make new points in reply, and when he does so, he invites you, says, I know it's a new point, but I invite you to respond. So in this case, Ms. Jiba didn't respond, but the memo from Audes SC makes it clear she never responded because she acted on legal advice. So we submit that in none of those judgments was she found to have been dishonest or lied. Now, as Ms. Bauer, during the course of a cross-examination of Ms. Jiba, also mentioned that a narrative has developed around these judgments. And that narrative, I don't claim to articulate it exactly or accurately, but it goes something like this. The NPA has been weakened by, amongst others, Jiba and Mrwebi. The independence of the NPA has been compromised. Public trust, or the public perception is that public trust and confidence have been eroded. Corruption has become rampant and is unchecked. And as Mr. Hofmeyer observed, no one seems to be jailed. Good people, this is now still part of the narrative, good people like Boysen, Breitenbach, Dramat, McBride, Boysen, Dramat, McBride, Gordon, Sapia, a few others, have been marginalized, have been victimized by the NPA, and Ms. Jiba is caught up in this narrative as being part of this, what one can only describe as a conspiracy theory. Now we know, as it's a matter of established law, if you have a conspiracy theory, you must prove it. So Ms. Jiba and others like Mr. Mcquarry are now paraded as the bad guys, along with Richard and Duly, along with our former president, along with our former president's relatives, with Pandey. And these names are just dropped very liberally during the course of evidence. So what we now want to proceed to do is to examine this narrative with reference to the facts, and we will conclude by submitting that these allegations are without any factual foundation. They are based on supposition, conjecture, inference, and hearsay. In many instances, they are recklessly made, which in itself, and I think I had an exchange with Mr. Hofmeyer during cross-examination, which in itself brings the NPA into disrepute. So we will now attempt to unpack this narrative with reference to what we hope you will accept as the objective facts, to determine and ascertain whether this narrative can be sustained based on the facts. And we will then consider the evidence later on of, amongst others, role players like Breitenbach, Boysen, and Hofmeyer. In fact, that is dealt with in our heads of argument. It was in the old pages 21 to 48. What would it be in the new pages? It's anyway, it's at the back of our heads of argument. Now, it is, according to this narrative, what page? 33 It's the evidence we deal with is from page 33 to the end of our heads of argument. Now, Jiba and some unnamed officials were or have allegedly been appointed to top positions in the NPA to further some nefarious objectives of, amongst others, our former president. So, when they made certain decisions, it is alleged that they did so in furtherance of ulterior objectives with ulterior motives. Now, at the outset, certainly having regard to the judgments that form a key part of the terms of reference, none of the judges, none of the judgments mention this, even allude to it at all. Ms. Jiba was she was part of the Scorpions from 2001 and 2008. And one of your esteemed panelists will be very familiar with the Mrwebi inquiry that looked into the Scorpions, and I think the evidence there was they had such a high rate, high success rate, something like 90%. So many of us, citizens, people were quite surprised and shocked when the Scorpions were disbanded. Advocate Mrwebi will know this, but certainly the Mrwebi Commission found that the DSA was permitted in terms of the Constitution. They carried out their mandate in terms of the law and then the Constitution, and because they were dealing essentially with complaints about overlapping jurisdictions and the use of resources between the police and the intelligence services. And I think a key issue was also that the Scorpions were acting as investigators and prosecutors at the same time. But the Mrwebi Commission found that this was perfectly compliant with the Constitution, and it was justified. But notwithstanding that, on the 20th of February 2009, through the SABC Amendment Act 57 of 2008 and the NPA Amendment Act 56 of 2008, the Scorpions were dismantled, dissolved. Now, it's important for this narrative for us to mention that at the time, the acting president was President Motlanthe. He was the president for the period from 25 September 2008 to the 9th of May 2009. Former President Zuma became the president on the 9th of May 2009, and he served until the 14th of February 2018. So, as an objective fact, unless someone can show that Ms. Jiba had some extraordinary powers or influence, we've seen that in recent days, the power of resurrection. That will clearly be too far-fetched to suggest even that Ms. Jiba had anything to do with the dismantling of the Scorpions. In fact, she served in that unit with distinction. So that all happened in 2009, and the panel will also know that she was also under suspension for quite a while in 2009 and part of 2010. She challenged the suspensions in the CCMA and in the courts, and eventually there was a settlement agreement. And that settlement agreement was with Advocate Mcquarry, who is not part of this narrative. And he was the acting NDP from September 2007 to December 2009. Now, in terms of this settlement agreement, Ms. Jiba was now going to be appointed as a deputy DPP in the Pretoria regional office. But she then made, and this is in her evidence, she made representation to Advocate Mcquarry, and she then took up a position in the SCCU, which was headed at the time by Advocate Breitenbach. You will recall Ms. Breitenbach's evidence. Ms. Jiba came and knocked on the door one day, and she said, "Sorry, there's no vacancies here." So that's what happened, and she worked in that unit. Important for this narrative also is to record that, so she's appointed in 2010, and prior to that, before she's appointed into any position of power, of real power and influence, because as we heard from Mr. Du Plessis, part of this narrative is an abuse of power in that office. The decision to withdraw charges against Mr. Zuma is taken on the 6th of April 2009. Now we know from the judgment, which I referred to extensively in my cross-examination of Mr. Hofmeyer, that decision was taken nominally by Mr. Mcquarry, but Mr. Hofmeyer was party to that decision. That was in 2009, and the panel will have this judgment, which I referred to, the judgment of NAFSA ADP, as he then was, which deals with the spy tapes saga, and he refers to another judgment which I think is also on the Dropbox, the judgment of NDPP versus Zuma, 2009-2 SA 277 brackets SCA, where the litigation between the NDPP and Mr. Zuma, where that what is described as a long and troubled history is set out in those judgments extensively. Now we know from this judgment that I referred and that I engaged Mr. Hofmeyer on, that Mr. Hofmeyer played a very, very critical role in, one, securing the tapes, listening to the tapes, and Ms. Jiba played no role in that whatsoever. We know that as the litigation progressed and the DA in the long line of litigation was also seeking to secure the tapes and the transcription of the tapes, we know that Mr. Hofmeyer and then subsequently Ms. Jiba formed part of what Advocate Kennedy, in his memorandum that is before the panel, described as a collective decision. And the memorandum of Mr. Kennedy also makes it clear that he advised the approach which then became the subject of criticism in the spy tapes case by NAFSA JA, which then criticized Ms. Jiba for her supine attitude, lackadaisical attitude, laid-back attitude, and an attitude which is not warranted from one that holds such high office. So this formed part of the GCP's application for the striking off of Ms. Jiba. Now we know on the facts before you that Ms. Jiba was actually acting on legal advice, the legal advice of Advocate Kennedy. Now, Ms. Jiba is then appointed as a deputy NDPP on the 22nd of December 2010, and Ms. Breitenbach's response that she was surprised, she may have even used the word shocked, because notwithstanding Ms. Jiba's extensive experience as a prosecutor, she jumped two levels. Of course, at the same time, Advocate Mokgoro, with no previous prosecution experience, had also been appointed as a deputy. In December 2011, we have the Simelane judgment in the SCA, and as a result of that, Advocate Simelane goes on special leave. And Ms. Jiba is then appointed as the acting NDPP on the 28th of December 2011. Now, if I may just pause at this point to deal, and it's also part of the narrative, is the pardon of Ms. Jiba's husband, Mr. Mr. Nancy. That is also built into this narrative. Now, rightly and fairly, the evidence leaders placed issues around that pardon in the Dropbox, and that's at J118. And from the documents there, it will become apparent that Mr. Nancy had already applied for his pardon in 2009, and it's in the Dropbox. So way before, clearly, I mean, way before there could have been any suggestion or contemplation of Ms. Jiba assuming an important, influential position of authority in the NDPP, in terms of which she would use or abuse her powers to advance some project. That application is made, it's motivated, and interestingly, he has, Mr. Nancy has two referees, one Advocate Dumisa and Sabeza, SC, and also Prince Mokgoro, who is the head of the NPA's integrity unit. Those are his referees. Anyway, the application is granted on the 8th of September 2010, which of course is just over 2 months before Ms. Jiba's appointment. No, a year, more than a year. More than a year before Ms. Jiba's appointment as the acting NDPP. And the application you'll see
Wait,
from
I'm
the,
so sorry, let me understand the maths. Pardon 2010, acting 2011. How do we get to more than a year?
no, the pardon was approved on 8th of September 2011. 2010. Sorry, did I say 2011?
Said 2010.
Yeah. Yeah, Ms. Jiba was appointed.
Depends when.
Yeah, but Ms. Jiba was appointed acting NDPP on the 28th of December 2011. So more than a year before that, on the 8th of September 2010, her husband was pardoned by President Zuma with the concurrence of the then Minister of Justice, Mr. Khadebi. Now, just around, because it's part of this narrative that we're trying to unpack, there were allegations that Ms. Jiba was on a flight on the 9th of September 2010, just round about the time when the pardon was approved. Now, there is no evidence that Ms. Jiba was on the flight. The evidence is actually that a Mr. Jiba was on the flight. And in any event, this was a flight that was going to go to Durban. I think the one allegation has been conceded and falls away, that she was also allegedly a spy, state spy or something like that. I wasn't present at the time when this evidence was led, so I deferred to my colleagues on the score, and it was a flight to Durban where she was allegedly on the plane with Mr. Duly, and they were going to meet some ANC officials. Not the president then, but some ANC officials. Now, it's apparent from the pardon that it appears to have been signed in Cape Town, and there's also an exchange of letters between Mr. Labaskachny and another state official in the time in Pretoria. So we submit that any suggestion, allegation that somehow this pardon plays a role in the appointment of Ms. Jiba and what she subsequently did or didn't do should be rejected on the basis of the evidence. In fact, at the time, Advocate Simelane would still have been the NDPP. He was the NDPP from December 2009 to December 2011. Now, we move on to Ms. Jiba's tenure as the acting NDPP, and as I said, that's from 28 December 2011 to September, October 2013. Now, she inherits the withdrawal of the fraud and corruption charges against Mr. Duly by Mr. Mcquarry, because the withdrawal of the charges, those charges against Mr. Duly by Mr. Mcquarry, takes place on the 4th of December 2011. She is appointed on the 28th of December 2011. Now, she was criticized by Justices Lagodi and Hughes in the North Gauteng High Court in relation to the Duly matter, and Mr. Justice Lagodi, who wrote the judgment, said that Ms. Jiba would do anything to help Mr. Duly and to prevent him from being prosecuted. And amongst others, he refers to a letter that Mr. Duly wrote to the President. Now, he writes that letter. Maybe the evidence leaders can assist. We weren't able to find that letter. It's dated the 3rd of November 2011. Yeah, where Duly says, "My chief, I'll do anything for you." Now, that's on the 3rd of November 2011. Ms. Jiba has not been appointed as the acting NDPP. Ms. Jiba, the decision to withdraw the charges against Mr. Duly by Mr. Mrwebi was done on the 4th of December, also before her appointment. And we submit that it, on the facts, to somehow to connect Ms. Jiba to this would be far-fetched. Now, on the 30th of September 2011, the prosecutor in the Duly case, that's now the fraud and corruption charges, one Smith, writes a letter to a memo to Breitenbach, where he makes out a case that there are prospects of a successful prosecution. So he obviously is informing his line manager, Mr. Mcquarry, of his views. And this memo is also copied to Ms. Breitenbach, who is his immediate line manager. On the 4th of December, Mr. Mrwebi writes to Mr. Mzinyati and Ms. Breitenbach, and he informs them of his decision to withdraw the charges. On the same day, the 4th of December, and that is at K, is it K2, what is this, K2? K2011, items 3 and 4 in the Dropbox. Yeah. On the 4th of December, Mr. Mrwebi also writes to Mr. Duly's attorneys, that's at K brackets 2011, item 7, to inform them of the withdrawal of the charges. Now, this is something that Ms. Jiba inherits when she assumes office as the acting NDPP. How are we doing with time? Now, upon finding out about the withdrawal, Ms. Jiba calls Mr. Mrwebi and Mr. Chauke for a briefing, and that would have been around about the 24th to 25th of January 2012. Now, at that briefing, and of course we know that Mr. Chauke was responsible for withdrawal of the murder charges, which is not the subject of any GCB application to strike off, or doesn't form part of the terms of reference here. But in relation to the withdrawal of the charges, the other charges against Mr. Duly, Mr. Mrwebi informs Ms. Jiba that the investigation is still continuing, that the withdrawal is a provisional one. There are certain aspects that require further investigation, and that the matter would be re-enrolled in due course. This, the reference here is the transcript at page 34 of the transcript of the 21st of February 2011. Sorry, this year, 2019. And so we submit there's nothing untoward Ms. Jiba accepting the say-so of Mr. Mrwebi, given the hierarchical nature of the NPA. He's the head of special projects, and the prosecutor in the case, Smith, and Ms. Breitenbach are accountable to him. Ms. Jiba's understanding of Mr. Mrwebi's decision to withdraw, but only on a provisional basis, subject to further investigation, is reinforced by Mr. Dramat's letter to Ms. Jiba of the 23rd of March 2012, where Mr. Dramat talks about an ongoing investigation. On the 30th of March 2012, Mr. Mrwebi writes to Ms. Breitenbach and to Mr. Msindiati, and he informs them that the decision to withdraw stands and that the matter is closed. We submit that this has nothing to do with Ms. Jiba. It is then only on the in the meantime, Ms. Jiba had also inherited the complaint against Ms. Breitenbach. That's the imperial, what is it called? That mining dispute. The Mendelow complaint, the attorney, that coal dispute seems to be ongoing, these coal disputes. We heard the evidence of Ms. Breitenbach there. It involves Advocate Allens, and because Allens was acting for one of the parties and so on. So the suspension of Ms. Breitenbach was recommended by HR at the end of February 2012. And in this regard, we ask the panel to refer to the evidence of Ms. van Rensburg, who was the then CEO. So it's recommended by HR, but the letter of suspension is signed by Ms. Jiba on the 23rd of April and delivered to Ms. Breitenbach on the 30th of April. According to Ms. van Rensburg, the process, the due process was followed, and there was nothing untoward about the suspension of Ms. Breitenbach. We also know that Ms. Breitenbach challenged a suspension both in the labor court and then subsequently in the labor court. She was found to be non-suited because a suspension is an unfair labor practice, and the LRA requires that an unfair labor practice must be adjudicated in the CCMA. But there's some useful comment made by Justice Rabker-Naiker in the labor court judgment. It's at B4. And there, Ms. Rabker-Naiker, presiding, said that there was no evidence to support the conclusion that Ms. Breitenbach's suspension and later her transfer were for ulterior purposes or had an ulterior motive. So the reason why I mention this now is because there's the Breitenbach memorandum, which formed part of the Duly matter taken up by the GCB. That memorandum is dated the 24th of April 2012. And it's been claimed by Ms. Breitenbach that she was suspended because she had written this memorandum to Ms. Jiba. So we submit that as a fact. You will find that this was not the case at all. A suspension related to a complaint that preceded Ms. Jiba assuming office as the acting NDPP. The suspension had been recommended by the Human Resources or Human Relations Department of the NPA, was presented to her by Ms. van Rensburg and was signed off, I would submit, as a matter of routine. Just to round off the issue of the suspension and Ms. Breitenbach's hearing, the evidence of Ms. van Rensburg was that everything was done according to the book, due process was followed, and as far as she is concerned, the hearing was a fair hearing. Of course, Ms. Breitenbach said the hearing was only fair because of the quality counsel that she had in the matter. Of course, that hearing was chaired by an independent chairperson, I think now Judge Selby in Benengwe. Full then launches the Duly matter on the 15th of May 2012. And we see the judgment of Murphy J. being delivered on the 23rd of September 2013. The decision was taken on appeal, and that judgment of Brandt J.A. was delivered on the 14th of April 2014. Then there's the GCB matter in the respect of Duly, which went before Justices Lagordi and Hughes, and we now know that there was a majority decision in the SCA. So far I was just talking about the Duly matter, one that she inherited. She never took a decision. She's been criticized for not responding and for not taking account of the Breitenbach and Ferreira memorandum. The next matter, a matter that she also inherits, is the spy tapes matter. And we've already referred to the long history of that matter, which is recorded in the SCA decisions. We would submit that in the light of the uncontested statement that that's part of the record, the statement of Advocate Kennedy SC, that matter is beyond debate. Ms. Jiba was not an active participant in the spy tapes litigation, to the extent that she was the acting head of the NDPP when it came to the DA asking for the tapes. She followed the advice of senior counsel and acted accordingly. And we submit that that cannot possibly be a basis for either finding that she was not fit and proper, or that somehow she misconducted herself in relation to her duties as the ANDPP. there clearly can't be any issue of her having any ulterior motive or purpose or some nefarious agenda, because the decision not to charge the president, which was now being reviewed, and of course we know it's been successfully reviewed by the DA, was a decision not taken by Ms. Jiba, but was a decision taken by Advocates Mcquarry and Mr. Willie Hofmeyer. That brings us to the Boyson matter. Now, we submit that what should put this issue beyond debate is the prosecution memorandum of Advocate Mayema, which we'll find at G 5.3.6 of the Dropbox. Just find it. Now, may I just mention, I'm not sure whether it's actually in our written hits, but the test to be applied for authorizations under Section 2(1)(e) and F, or Section 2(4) of the Poker Act, that test is laid down in the two cases of Chow and De Vries. They are both Cape High Court cases. And there the High Courts have laid down a quite a low threshold, and as we know from that Section 2 itself, that even hearsay evidence may be taken into account. And with respect, Lagodi J in his judgment, written together with Justice Hughes, deal with this quite effectively in their judgment already, dismissing the complaint against Ms. Jiba in relation to Boyson. Now, if one looks at this memorandum, it is a detailed memorandum. There's an introduction. In paragraph 2, the unlawful activities of the enterprise began to manifest themselves from May 2008 to 2011 through a pattern of racketeering activities. They killed members of the KwaMapumulo Taxi Association, which was in conflict with the Stanger Taxi Association, ordinary civilians and suspects, and criminal gangs suspected of ATM bombings. In some of their killings, the unlawful activities were motivated by the desire to enrich themselves through state monetary awards and or certificates for excellent performance and financial benefits. The state has grouped the preferred predicate offences by association and or method of operation as killings relating to taxi violence, ordinary civilians or suspects, and ATM bombing suspects as described below. So it's a long memorandum, which I'm sure the panel will have regard to. And at after paragraph 16, the accused persons are identified, accused number 1, Johan Wessel Boysen, and just while I'm scrolling, Madam Chair, honorable members, I think it's also important to bear in mind that this matter is still before the courts. In fact, it's coming before the court again on the 4th of October this year. The analysis of the evidence is described from paragraph 17 onwards. A list of proposed charges are incorporated in the memorandum. And now I don't have the two cases, Chow and De Vries, in front of me, but I can assure the panel that what those cases say, it's enough for the NDPP, or in this case the acting NDPP, to have a memorandum in front of him or her, in the kind of memorandum that you see in front of you. And here Advocate Maema, who's the prosecutor, summarizes the case. It's sufficient for the NDPP to satisfy himself or herself that there is indeed a prima facie case that must be answered, and to issue the authorization. In fact, maybe this response, ma'am, is long overdue, but here is, we assisted here with the reference to the poker racketeering policy. Mr. Maema records at paragraph 33, it will be impossible to charge the accused individually with the offenses they have committed. Charging the accused together outside the ambit of poker will result in misjoinders. The poker prosecution will allow the joining of different participating accused, which is otherwise not permissible. A poker prosecution will enable the state to charge the accused with all offenses committed through a pattern of racketeering activity distinctly and separately. Section 2.2 of poker allows the court to hear evidence with regard to hearsay, similar facts, or previous convictions relating to offenses contemplated against the accused. The placing of firearms on the crime scene is similar fact evidence. Then anticipated defenses at paragraph 37, section I, the accused will argue self-defense and rely on section 49.2 of the Criminal Procedure Act. They will also argue that they not participants in some of the crimes scenes, essentially relying on dissociation. The accused would also raise a defense of bare denial on the charge of theft, assault, possession of unlicensed firearms and ammunition, and malicious damage to property. The state will counter these defenses with direct evidence, circumstantial evidence, expert evidence, real evidence, documentary evidence. Some of the deceased were not suspects. Some of the deceased were, found? Or shot, sorry, shot in a supine position. They acted maliciously in a quest for personal benefits, and the list is not exhaustive. Is it not in evidence? Ma'am, I'm just can you, if you don't mind, if you just record the references to these cases. S.V. Chow, CHAU and others, 2009.
S
These,
versus Chow
Chow,
or Chow.
CHAU.
CHAU.
C-A-A-O, C-H-A-O. Maybe I'm thinking of Chow. You know,
Give us that
I'm from Cape
citation.
Town. We think about Chow all the time.
Just give us
2009 2SA 895 bracket C 595. C
Slower.
paragraphs 32 to 33 and paragraph 35. And the other case is the case of De Vries, S versus De Vries, 2008 brackets 4 SA 441 bracket C, paragraph 27, 28 and 33.
How long are you going to be on that point?
I'm rounding this point off now,
Okay.
ma'am, and
I just wanted to determine when to break for
then
lunch.
perhaps it's a convenient point too.
Yeah.
So the prosecutor in the case then, at the end of this lengthy memorandum, he concludes and he recommends that authority be granted for the prosecution of the accused as proposed in the indictment, and that certificates in terms of 2-4 of poker be issued. And the proposed indictment is attached and it's signed by the prosecutor. So, just to round off there, no direct involvement by Ms. Jiba at all. These are done by prosecutors, and of course, before that, by police investigating these charges, and she's requested by the prosecuting team to sign the authority, and she signs the authorization. And we submit that absent any evidence of mala fides or bad faith or ulterior motive or purpose, absent any such evidence, that the panel will also find that the authorization to charge General Boyson was entirely appropriate and in accordance with the law, as was found by Justices Lagodi and Hughes and endorsed by the majority of the SCA subsequently. So, yeah.
So that's it for now? Yeah, thank you. And I think we can adjourn for lunch. Would it be appropriate if we take a shorter lunch? We come back at 1:45. Thank you. We adjourn until 1:45.